Good afternoon, everyone, and thank you for joining us for today's webinar on workers' compensation and COVID-19. I'm Mike Gifford from the Branding and Stakeholder Engagement Unit here at the Workers' Compensation Board. Today we'll discuss the basics of the workers' compensation system, as well as information to help workers who believe they contracted COVID-19 on the job, especially those who have missed time from work or are suffering from ongoing or long-haul symptoms. We'll be using the chat feature to receive your questions. Please enter your questions throughout the presentation in the chat box that's located on the right side of your screen. We'll answer as many of your questions as we can, but if you have questions that we don't get to today, or you think of something after the session ends, we'll be providing you with resources at the end of today's presentation. Your name and email were given to us when you signed in today. However, if you have a specific topic you'd like to discuss more deeply with the board, please share that topic along with your email address in the chat box so the appropriate board staff can follow up. The chat settings are set so that only panelists can see any questions or comments that come in, so you don't have to worry about others seeing your personal information. Joining us today to assist with answering questions, we have the board's medical director, Dr. James Tachi, and advocate for injured workers, Joe Cavalcanti, who is going to say a few things to kick things off.
Thank you, Mike, and thank you everyone for joining us today. The Office of the Advocate for Injured Workers here at the board exists to support the injured workers of New York State. We are here for you. So in today's presentation, we'll be sharing important information about workers' compensation for employees who have contracted or who do contract COVID-19 due to an exposure in the workplace. As part of this, we'll be detailing how and when to file a claim. And the when here is very important. And it's one of the key reasons why we're doing this webinar and why we have done it for the past 3 years. Workers have 2 years from the time they contract COVID-19 to file a claim. So if you believe you contracted COVID-19 in the workplace 2 years ago, or roughly June 2022, you need to file a claim now. You will also learn what to include in your claim to show that you had COVID and that your COVID-19 was work-related. I look forward to answering your questions at the end of the formal presentation. So to get started, I'm now going to turn it back over to Mike.
Thank you, Joe. Let's take a look at today's agenda to start. We'll begin by explaining what workers' compensation is and what your rights are if you become injured or ill on the job. Then we'll discuss how workers' compensation can help those affected by work-related COVID-19, including workers who are facing ongoing or long-haul symptoms. We'll talk about the importance of filing a workers' compensation claim and walk you through the process of doing so, including the medical documentation that's needed to support your COVID-19 claim. Finally, we'll point you to some helpful resources for more information or assistance with filing, and we'll leave time at the end to take any questions. So let's start with a brief overview of workers' compensation. Workers' compensation is a no-fault insurance system and is usually covered by insurance through an employer, unless self-insured. We'll discuss this more a little later in the presentation. An employer cannot charge a worker for the cost of this insurance, and it provides medical care and lost wage benefits to workers who are injured or become ill on the job. An employee is considered anyone providing services to a for-profit business or any compensated individual providing services to a nonprofit organization, regardless of employer size. The only exceptions are clergy and some school teachers, although the vast majority of school teachers in New York State are voluntarily covered. There is no cost to the worker to receive the necessary medical treatment for a work-related injury or illness. This is a lifetime benefit, unless a worker signs a settlement or Section 32 agreement that closes any medical eligibility for a payment. This includes all medical expenses such as tests, hospital visits, medications, physical therapy, equipment, and home care attendance. Transportation costs for travel to all medical appointments or treatments are also reimbursable for life, and there is no time limit to when a worker can file to have these costs reimbursed. Now let's discuss the workers' cash benefits, otherwise known as indemnity benefits. 2/3 of a worker's average weekly wage is payable while the worker is out on workers' compensation with 100% disability. This includes all compensation, for example, tips and perks. The maximum benefit is now $1,125.46 per week. This is based on New York State's average payroll and is recalculated every July 1st. Benefits in the workers' compensation system are temporary, except in the event of a permanent injury. In that case, the worker will be evaluated to determine whether they have a permanent total disability or permanent partial disability. Finally, there are payments for a loss of use of a limb. This is known as a Schedule Loss of Use Award and may be eligible for injuries to the following: arm, hand, fingers, leg, foot, toes, eyesight, hearing, or disfigurement. There is also a fatality benefit, which is payable in instances where a worker perishes due to an incident, consequence of a previous incident, or an illness, such as COVID-19, at work. With this benefit, funeral and memorial expenses are reimbursable up to $12,500 in the New York metro area and $10,500 throughout the rest of New York. Surviving family members are also entitled to weekly benefits, which are calculated the same way as the indemnity benefit, 2/3 of the deceased worker's average weekly wage. Beneficiaries include the spouse of the worker, children up to the age of 18 or 23, and any disabled or blind dependents. If none of these parties exist, $50,000 is payable to the parents of the deceased worker. If there are no surviving family members, $50,000 will be paid to the estate. In terms of who pays workers' compensation claims, that depends. If your employer purchased an insurance policy, the insurance carrier who wrote the policy pays the benefits. If your employer is self-insured for workers' compensation, your employer pays claims. Usually, self-insured employers use a claim administrator to handle claims, so you will be interacting with that claim administrator in that situation. That's known as a third-party administrator. When the employer does not have the required workers' compensation insurance coverage in place, the Workers' Compensation Board will pay claims so workers can get needed benefits, and then the board recoups the costs from the employer, along with any penalties for not having the insurance in the first place. Workers' compensation is a worker's legal right. If you are injured or become sick at work, you are entitled to workers' compensation. It cannot be negotiated or signed away. Immigration status is not a factor, and the board offers free language assistance if you would like it. So, what is the role of the Workers' Compensation Board? The board administers and oversees the workers' compensation system. However, as previously mentioned, we do not typically pay the claims unless the employer has failed to provide proper workers' compensation coverage. We have approximately 1,000 employees statewide. Our role is to ensure the system operates correctly by receiving reports of all injuries, payments, medical reports, and any other documents related to the claim. We will also hold hearings in front of an administrative law judge when appropriate to adjudicate or move a claim forward. Hopefully that gives you a high-level understanding of the workers' compensation system, your rights and benefits if you become injured or ill on the job, and the role of the Workers' Compensation Board. Now let's discuss what you need to know and what actions you should take if you contract COVID-19 at your workplace. The first thing to do when you are sick or injured on the job is to seek treatment. In an emergency, you can seek any healthcare provider, but otherwise go to a provider who is authorized to treat injured workers by the Workers' Compensation Board. You can find one using the provider search on our website. You can also visit your local New York State occupational health clinic for treatment from an authorized provider. You can search for your closest clinic on the DOH website, and that link is on the slide. Tell the provider who treats you that you believe you contracted COVID-19 from an exposure at work. Share any details about your workplace to back that up. For example, how would you describe your workplace? Was there public contact? Were masks worn? Did your coworkers have COVID-19? As well as any other circumstances the provider should know about your potential exposure. If your healthcare provider agrees, they will send a medical report to the insurer and to the board. You will need to notify your employer in writing that you believe you contracted COVID-19 at work. An email or a document is best. A text message can be accepted, but it's not recommended because it's not easy to find and duplicate if necessary. Notify your employer as soon as you can, but no later than 30 days of becoming ill. Your employer is then required to notify its workers' compensation insurance carrier. Now let's take a look at how to file a COVID-19 workers' compensation claim. You should file a claim for workers' compensation. Workers are not required to file a claim because the insurance payer must notify the board of the incident. However, filing your own claim is a valuable protection and is extremely helpful, as I'll explain in a few minutes. You have 2 years from the time you contracted COVID-19 to file your claim. So, if you are approaching this deadline, you need to file a claim as soon as possible. The fastest way to file the employee claim form, the C3, is online. You can visit the COVID-19 area of our website, and that link is on the slide. You can also file a paper form, which you can download from our website. Follow the instructions on the form for submitting it to the board. We'd like to note that the C3 form you fill out is the same form used for any injury or illness experienced on the job. It's not specific to COVID-19. If you have questions while you're filling it out, don't hesitate to contact us. If you have a PCR test, results showing you had COVID-19, file that report. That's very important to your claim. If you had COVID-19 early in the pandemic and got your results by phone, as many people did, you should now get that result in writing and file that. So what do you need to share in your claim to show your COVID-19 illness is work-related? Most workers cannot point to the exact moment or method of exposure to COVID-19. However, you can demonstrate a high risk in your workplace if you work in an environment where exposure to COVID-19 is or was prevalent. For example, a hospital, a transportation job, the grocery store, or anywhere else. On the claim form, include details about where you work, how often you work, and your job duties, especially those involving public contact. Section D of the claim form has space for you to share any relevant details. While not all claims will be accepted, there is no harm or risk in filing a claim, even if it ends up being denied. Filing a claim is important for anyone who believes they contracted COVID-19 at their job, and especially those who are missing work or experiencing ongoing symptoms, as there may be benefits that can help you right away. If you are experiencing long-haul medical issues due to work-related COVID-19, you may be eligible for free lifetime medical care. If you miss more than 7 days of work due to the work-related COVID-19, you may be eligible to receive lost wage benefits. This may be very helpful to long-haul sufferers who regularly miss time from work due to medical appointments or worsening symptoms. For anyone who contracted COVID-19 on the job, whether or not you had access to and used paid sick time, whether or not you've since recovered, it is important to have an established claim, a record that your COVID-19 was work-related, should you suffer long-haul complications and need workers' compensation benefits down the line. If you already have an established claim for COVID-19, any lost wage benefits or ongoing medical care that is directly or consequently related to COVID-19 falls under that existing claim. For example, someone with an established COVID-19 claim may also need ongoing treatment for problems from COVID-19 related to their kidneys or lungs, or may develop consequential conditions such as anxiety and depression. If the treating provider thinks that a new condition is related to the work-related COVID-19, it should be sent to the workers' comp insurer, who will either accept the provider's medical opinion or seek resolution as to whether it's related by the board. Also, you should see a board-authorized provider. Please make sure to have the following information for the provider: your WCB claim number, the carrier case number, and the name of the insurer. If you need help filing a claim, you can call our toll-free customer support line at 877-632-4996. Free language assistance is also available. If you face resistance or obstacles to getting information about the claims process or are discouraged from filing a claim, please let us know. We will help you. Email our advocate for injured workers at advocateforinjuredworkers@wcb.ny.gov. So, what happens once you file? If the insurer accepts or agrees with the claim, it will be payable. This is known as compensable. If the insurer disputes the claim, a judge at the board will decide whether the claim should be paid. Right now, everyone has to attend our hearings remotely because our offices are closed to the public. While the attorneys must attend by video, injured workers have the choice to either participate by telephone or by video through the virtual hearing center. Your hearing notice will contain all these details. The judge may hear testimony to get the facts about where you work, whether you were exposed to COVID-19, the extent of exposure, and whether exposure to COVID-19 was prevalent in your work environment. Remember, you do not need to pinpoint a moment in time when you think you were exposed. We review all the facts in a claim. From there, it is possible to appeal a judge's decision, and we have an appeal process if that happens. If you file a claim within 2 years of contracting COVID-19, but your claim was incomplete, you will need the following: a positive PCR test result and possibly a medical report, any other documentation the board has requested or directed at a hearing. Please submit this information as soon as possible. Once all materials are submitted to your board file, your attorney can request a hearing. If you do not have an attorney, you may file a Request for Assistance by Injured Worker, Form RFA-1W, or its online version, which are both available on the Forms section of our website. Now we'll take a look at the additional resources that are available to you. For more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and filing a claim, please visit wcb.ny.gov/COVID-19. On that page, you'll also find numerous resources such as fact sheets, frequently asked questions, and more. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button on the top of the page. For other helpful information for workers on workers' compensation and other topics, you can visit the Workers page of the board's website. Finally, our Advocate for Injured Workers is also at the ready to help injured workers who are having difficulties with their claims or trouble accessing their benefits. You can contact the Advocate's office by calling 877-632-4996 or emailing advocateforinjuredworkers@wcb.ny.gov. We have a very active social media presence to help you stay informed on workers' compensation topics and for the latest news from the board. Follow us on our social channels to learn about future webinars just like this one, as well as information and webinars on New York State paid family leave. Our Twitter or X, Facebook, Instagram, and YouTube are available on the screen. Thank you for attending this presentation on COVID-19 and workers' compensation. We hope you found this information helpful. We will now take the rest of the time to answer any questions that you may have. As a reminder, please submit those questions in the chat box, and we may be taking a few moments between questions to review the questions submitted, and we'll be back shortly. Thank you. Okay, we see a lot of questions coming in. First, I will take one that is asking if participants can receive a copy of the slides, and yes, keep an eye out on your email. We'll do a follow-up that contains the slides and a recording of today's webinar. But just a reminder that this information is active on our website right now, so you can go to the COVID-19 webpage where past webinars are available.
Mike, we have gotten a few questions in that we'd like to answer. We'd like to begin back at the first question we got, which came in very early, and someone gave a good amount of personal detail, but I'm going to simply answer the question and give you the principle, because this is a general workers' comp principle for the state of New York. Your benefit rate is determined by the date of injury. So if you were injured 25 years ago approximately, as our question writer was, then the benefit rate that was in effect 25 years ago, or date of injury, that is going to be the benefit rate you shall receive for the life of your claim. The next question is another general principle. It has to do with the 30 days to provide notice to your employer on the one hand, and then 2 years to file a claim. Okay, we have been mentioning that you should tell your employer that you did have an incident, and you should do that within 30 days, and you should do it in writing. Okay, that is a general thing that you ought to do, and it's extremely important because that will get your claim started, because now the employer tells the insurance payer, and the insurance payer must tell us, or there's going to be a financial penalty. So that's an extremely important thing that will start your claim. On the other hand, if you don't do that and you're telling them 35 days later or 40 days later, fine. Just proceed forward, okay? Don't preclude yourself. Just proceed forward. On the other hand, you definitely have 2 years to file a claim. So if something happened and that notice didn't come in, you have a total of 2 years to file your claim. Now, we also had another question that was more specific to COVID, and here's that one. This is question number 3 now. Does an employee file an additional C3 form and provide new details if they have another exposure and miss work? Okay, here's the general principle here. A claim is specific to an incident. So let's say you got COVID January 1st, 2021. You filed a claim, you have a claim. Very good. Let's say that unfortunately you got COVID again on January 1st, 2024, or 3 years later. If you again believe that you contracted COVID due to employment, yes, you should file another claim because that is a separate incident. However, on the other hand, let's say you had your COVID January 1st, 21. Okay, you filed, you have an established claim, and let's say you're suffering from what's known as long-haul COVID. And so as the time is passing on, you're having these symptoms and these difficulties that are keeping you out of work because of that COVID you got on January 1st, 2021. That is one claim. You're just going to be receiving benefits off that one claim. You do not need to file anything else.
This is Dr. Tachi. I'll jump in. There's a question, how common or difficult is it for an employee to prove that they contracted COVID-19 while at work? And I would say that there's not a precise answer to that because every case is individualized. As was mentioned earlier, if you contract COVID and you think, first of all, you'll seek appropriate health care. If you think that it's related to work, you'll mention that to your healthcare provider, and they will put together, the medical information that they believe supports the notion that your COVID was contracted at work. Yes, some cases are pretty clear cut. I was a doctor working on a COVID ward, and we ran out of masks, and 10 people coughed on me, and the next day I had COVID. As an example, that's pretty clear cut. Versus I was working from home on my computer, didn't leave my house for weeks, and I contracted COVID. So those are two pretty clear-cut, different ends of the spectrum examples. And everything else falls somewhere, probably in the middle. And I would say that the board has cast a pretty wide net and wide definition in terms of both insurance payers, employers, and the board accepting COVID claims. So again, if your healthcare provider makes a pretty reasonable argument as to why they believe that your COVID claim is related to work, there's a pretty good chance that would then get accepted. But every case is different, like the two examples I gave.
Hi, this is Keith Longden from the Office of General Counsel. I've got a question that says, hi, as a New York State employer, we have paid for lost wages per state guidelines. An employee who feels they've contracted on the COVID on the job would not receive wages beyond COVID pay, correct? There is employers who continue to pay wages while an employee is injured due to a work-related injury. They are able to get reimbursement from the workers' compensation carrier for those wages paid, and the injured worker will not be able to get benefits in addition to the wages paid. Although if they do have an additional period of lost time for which wages aren't paid, they can get additional benefits paid under the workers' compensation law by the carrier. Next question says, what does MMI mean? How does it affect your monetary benefits and your medically necessary medical treatment and medications? MMI stands for maximum medical improvement. That means your condition is, as you've recovered as much as you're going to. You're not going to get any better. Your injury is recovered, and we can classify, the main effect that has is you can be classified with a permanent disability if the medical evidence supports that finding. You can continue to get monetary benefits, although permanent disability benefits, unlike temporary benefits, are capped at a certain number of weeks depending on your loss of wage earning capacity. You continue to get medical treatment. You continue to get medications for the rest of your life, though.
Thank you, Keith. At this moment, we don't have any more questions in the chat box, so we'll just give it a few minutes here if anybody has any questions that pop into mind.
Now, while we're waiting, I'll just dovetail off. This is Dr. Tachi again. I'll just dovetail off of Keith's last comment. A lot of times, claimants will worry if they're found to be at maximum medical improvement that they'll stop receiving medical care, and that's not the case. As Keith mentioned, you continue to receive medical benefits for the rest of your life. And just again, as an easy example, if you sustained a knee injury, let's say, and you have a certain limitation to your range of motion of your knee, and that's not ever going to get any better. It's gotten as good as it's going to get. Well, your knee injury has reached maximum medical improvement, but you might walk with now a knee brace and you might need a cane or something. And those items don't last forever. So, as they wear out, you're going to have to continue to see your provider. They'll have to maybe measure you for a new knee brace, provide you with a new cane, et cetera. And that's just a simple example, but the important point is the medical benefit for your injury, even if you're at MMI, continues. So that should not be a concern or a worry.
Thank you, Dr. Tachi. We'll give it a few more minutes here if anybody thinks of any questions they'd like to submit before we close out the webinar today. Thank you.
We did get a question, and the question reads, how are attorneys paid? All right, since we have a moment here, let me speak for a moment about this topic because it's fairly important and it's a pretty big topic. Number one, if you're an injured worker, yes, if you would like to have an attorney represent you, you certainly may. That is your right. I will go a little further and say there are occasions when it's definitely probably a pretty good idea for you to have an attorney. For example, let's say your claim is formally disputed or controverted, as we say. How is the attorney compensated? Workers do not pay the attorneys directly, so that's off the table. What happens is the attorney will be compensated based on the work performed relative to the amount of benefit the worker is receiving. The attorney will receive up to 15% of the benefit in certain circumstances, and that will be approved by a judge. So you will see it if you're the worker, you will know what's happening, and it's only going to be, the attorney's only going to be compensated if money is moving towards the worker. And the insurance payer will actually pay the worker directly, and they will actually pay the attorney directly. So that's why the worker never pays the attorney. Now, your next question might be, how do I retain an attorney in this system? Well, there are a couple of resources I'd like to bring to your attention. Number one, you can contact the New York State Bar Association. New York State Bar Association. I think their URL, their website is nysba.org. So if you contact them, they will send you some names of attorneys who practice workers' comp. You may also contact this organization that's known as the Injured Workers Bar Association. That's a group of attorneys who tend to represent injured workers. They've created their organization, their own organization. If you contact the Injured Workers Bar Association directly, they will give you some names. And then finally, on the board's website, you might want to look up under representatives, there's something called licensed representatives. These are people who have a license to represent injured workers, and the license is granted by this agency. So you can get names for yourself off of that list.
There is a question, how do medical bills from non-authorized providers get paid? The answer is a little complicated. First of all, providers are supposed to be authorized in order to provide care. There are exceptions that are made for when emergency care is provided. There's exceptions that are made for out-of-state providers, and there's exceptions that are made, say, for certain types of providers who are not able to get board authorized. A good example would be dentists. I think the important message for you all is that you should never be receiving a bill. So when you're receiving medical care for a work-related injury, the provider will be submitting the bill for those services to the payer, and then the payer and the provider and sometimes the board will sort out how that provider gets paid, whether they're authorized, not authorized, again, out of state, et cetera. But you as the patient should never be receiving a medical bill for your work-related injuries.
Hi, we have a question that has to do with Medicare, or I'll extend it to a general principle. How would Medicare get reimbursed if it turns out that this is a workers' comp claim? Or how would your private health insurance get reimbursed if they paid expenses and the expenses were ultimately part of an established workers' comp claim? Okay, that does sometimes happen. And the good news is, don't worry about it. There is a well-established thing called the Health Insurance Matching Program, or HIMP, if you really want to know the acronym, wherein the comp insurer will reimburse Medicare or your private health insurance if that's who paid it. The insurance payers are very good at exchanging funds when funds need to be exchanged. We have a question that we're not quite certain what the person is asking, but I'm going to make an attempt at it anyway. And we believe, well, the question is, how are multiple injuries calculated to determine maximum benefit number of weeks? So we believe that we're getting at an instance where a person might not have COVID, but might have had an incident in the workplace wherein multiple injuries were suffered, multiple body parts were impacted by the injury. And yes, it can happen that someone can have an injury that impacts different limbs, different body systems. Yes, that can certainly happen. So the doctors, the treating doctors, will come up with a degree of disability. How disabled is this person? Based on that incident, and it will be a number that ranges from 0, which means you're healthy, terrific, to 100% disabled, which means you can't actually work right now. Okay, so the treating doctors will come up with that degree of disability and will include the various body sites that were impacted by the incident. How is it determined the number of benefit weeks? Okay, so our person is continuing the question. Well, you know, if you're temporary or if you're permanent. Okay, so if you're suffering a temporary disability, this was what Keith was speaking about earlier. If you're suffering a temporary disability, okay, there's no limit on the number of benefit weeks. However, let's say you have a permanent disability. This is what we were speaking about earlier. Well, if it's a permanent partial disability, which is anything less than 100%, 100% is total. If you have a permanent total disability, you could receive the indemnity payment for life. If you are permanent partial, which is 95% or less, you're going to have a period of time between 4 years and 10 years. It's going to depend on the number, on technically your loss of wage earning capacity. That is the technical thing in our system that then maps over to the number of weeks of benefits. So, to the writer of this question, if you really have a specific issue related to yourself, why don't you send an email to my office? I think we have the contact info on screen probably, and there you go. And include your WCB case number, please, okay, the 8-character WCB number, and we can take a look at this for you and tell you specifically what's going on in your claim.
Looks like that's all the questions we have received today. Once again, thank you for joining us today. Just a reminder that more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and filing a claim, can be found on our COVID-19 webpage. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting Subscribe for Updates on the top of the page. To receive other workers' compensation news, including information on future webinars, visit our website, scroll down to the bottom of the homepage, and select Get WCB Notifications. For other helpful information for workers, you can visit the Workers page of the board's website. Thank you again for joining us today, and we hope you enjoy the rest of your afternoon.